뭐 읽으실 건가요? 읽으실 거면은 제가 읽어보는 게 읽으실 건가요? 그냥 중간하실 건가요?
제가 얘기하면은 트랜스레이트 하시는데 이것을 미리 보면 좋죠. 내가 이슈가 되는 이유.
Did you say 3, Dana? Did you say 3? Okay.
Say Joe. Hi, I'm Jeff. Nice to meet you. And the interpreter is...
Yes, here.
Hi. So you've already got to know them.
Well,
At least try to converse and
yes.
build up some kind of rapport. Okay. Are you going to be able to simultaneously translate, or do you need us to stop so you can translate?
Well, whatever the proceeding is will have to be done simultaneous, but for testimony it'll be consecutive.
Okay.
So both. Whatever the general proceeding will be
Well,
simultaneous.
I'm in charge of that, but I want to do what's easiest for the parties, right?
Right. Well,
So, for instance, when they're explaining what they did, you'll need them to stop periodically so you can.
yeah, that's
translate?
consecutive. Yeah, whatever the actual testimony
Okay.
will generally be,
All right.
as in court setting.
Okay, so we'll do
Yeah.
it consecutively.
We'll do it like we did last week.
I can't think of anything else. You've done this once before, I know, because I watched. I was in the audience.
Try them all out. I just figured it was convenient. Hey, is the Wi-Fi not up here? The light Wi-Fi?
Oh, I was Wi-Fi.
Oh.
Down here, so actually,
I have a little. I'm not trying to hear your thing, so maybe.
Hold on, recovering from hotspot.
Thank you, Mike.
In the slide, yeah. Yeah, yep, yeah. Okay.
That's for part of the live stream. They're sensitive, so if there's whispering, it could be done.
Right.
So probably that's another reason we should do consecutive instead of concurrent, because it would be clutter noise in the background. So
Okay.
just whispering.
Thank you. Yeah, we can have. You already mentioned in your statement. You already talked about it in that statement. So I'll tell them that we have them and they want to examine
It doesn't. So the exhibits,
I pulled them up as
yeah, they start over. It's like 1 through 11, and then it starts back over again at 4 through 11.
Oh.
So it's duplicated.
Is that for a reason?
I think it's an accident.
Oh, okay. So 7, 11, and then
The index is right, but physically,
it's wrong.
there's an extra set of 4 through 11. In
Oh, okay. I'll just use the bookmarks.
Yeah.
Okay, I see. I gotcha. Goes back to 4.
I have to read them. That's okay, I'm sure. 전화는 꺼버리지. 어차피 나한테 버리고. 찾은 사람이 없어. 또 버리고.
Oh my God, I want to introduce myself.
한국말로
So do you understand?
한국말로 하시는 게 더 편하실 텐데 이거는 단지 일종의 요약이랄지 굳은
그렇지.
단지
Where are my son?
But
본인 말로 하셔야지.
본인말로.
but this is just
이건
an outline of what
그 요약이지 본인 말로 나와야 돼요. 어쩌면 이거 보시지 않는 게 더 좋게 보일 거예요. 본인 입에서 말이 나와야 되는 거니까.
Okay. And your name, sir? So Lisa Renati.
We have to read this, I don't
So
know.
that's Scott.
I don't need
Okay.
to.
Okay.
Who's gentleman next?
These are the representatives from the CDGFA.
영어로는 그 항소라고 안 하고 불복 신청이라고 해요. 불복 세금에 대해서 불복해서 신청하는 거. 저쪽은 피청구인 쪽이고.
저쪽은 내 적이네.
저기 있어.
적이네.
So I want to clarify whether all the proceedings should be interpreted or just a question and answer. Should I check on what they are?
Mr. Anjija is going to give the guidelines for how we're going to proceed.
Got it.
Everybody ready? Let's go on the record. In the Office of Tax Appeals oral hearing for the appeal of, pardon me if I get it wrong, Myun Chang and Jae-won Chang. And the appeal number is 1801-1865. And before we proceed, we have an interpreter for this appeal. I need to qualify and swear in the interpreter. So could you please state your name for the record, and briefly, what are your qualifications as a Korean language translator? It should be.
Interpreter's name is Ted Kim, Tedkim. State of California Certified Korean Interpreter, certification number 300380.
That will do. Please raise your right hand. Do you solemnly swear or affirm that you will accurately translate from English into Korean and from Korean into English to the best of your ability? Okay, thank you. This will be a full translation. We're going to try to go consecutively. So I'd ask the parties to please, you're actually doing it consecutive right now. If you're okay with that, I can simultaneous. Try not to talk over each other, and let's speak directly into the microphones. All right, and so now we'll proceed. It is 10 o'clock. We're in Sacramento, California, and this is Wednesday, September 25th, 2019. My name is Jeff Anjija, and I am the lead administrative law judge for this hearing. My fellow co-panelists today are Sarah Hosey and Mike Geary.
Good morning.
Morning. Appellant, could you please identify yourselves for the record?
Morning, from TCHR for the appellants,
불복 신청자의
Myun Chang and Jae-won Chang.
Okay, thank you. And for CDTFA?
My name is Scott Lambert, and to my left is Kevin Hanks. And to Mr. Hanks' left is Chris Brooks.
Thank you. And this appeal involves one issue, which is whether reductions are warranted to the measure of unreported taxable sales. And during our pre-hearing conferences, the parties agreed to the admission into evidence of appellants Exhibits 1 to 4 and CDTFA's Exhibits A through K. Neither party had any objection to the admission of those exhibits at that time. Is that still correct?
That's correct.
And then after the pre-hearing conferences, appellant had 7 additional exhibits, which we marked 5 to 11. And we've distributed those to the parties. Does CDTFA have any objection to the admission of those documents?
No objection.
I hereby admit appellant's Exhibits 1 through 11 and CDTFA's Exhibits A through K. And based on our pre-hearing conference, it's my understanding that both appellants will testify.
Actually, Mr. Chang will be the only.
Okay. And then as we agreed during the pre-hearing conference, we will begin with appellant's testimony and argument. In light of the translation, we've allotted 60 minutes for that. CDTFA will then be allowed to ask questions if they wish. And then CDTFA will make its presentation not to exceed 30 minutes. I think that's counting the translation. And the co-panelists can ask questions if they wish. And then appellant will have approximately 5 minutes to respond to CDTFA's arguments. All of that is an estimate based on the translation. So with that, I will swear in Mr. Chang. So please stand and raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, thank you. And Ms. Seichao, when you're ready to begin, go ahead.
Thank you. Good morning. We are here today because Mr. and Mrs. Chang are entitled to additional reductions to the audited sales determined by the department. The dispute or the disagreement.
If I can stop you, maybe we move that microphone if we're going to do a simultaneous, slide it out of the way. because we're hearing both of you at once. Thank you.
Disagreements can be broken up into three different areas. One, the average sales rates apply to what we call the break periods. Two, the number of days the department has determined to be regular business days. And three, the hours of operation of the restaurant. In this case, the total of the department's adjustments are broken into the three separate adjustments that I just mentioned. The department looked at three different sets of data to determine the audited sales figures. One, and what I would call the break period, the second sales period, what I call the regular period, and three, sales in what I will call the additional 2-hour period. Mr. and Mrs. Chang operated a cafe called Peanuts. This cafe was located very closely to San Jose State University. And their hours of operation closely followed the school's hours of, I guess, the academic calendar. When I use the term break period, I'm referring to the entire time between winter and spring school semesters and the summer break. This is in contrast to the regular period, which is the start of instruction through the end of instruction. The department's break days consist of holidays, Fridays, Saturdays, Sunday, and the months of October, November, and December. It's important to distinguish between the break days and regular days because the hours of business were different and the sales differed significantly. While the parties agree as to the number of business days, we disagree as to the number of break days versus regular days. The improper average sales rate was applied to a larger number of regular days than there actually were, and appellants are entitled to reduction for this error. Appellants have provided a summary of Peanuts hours, which is located on Exhibit 4, and an analysis of the number of break days versus the regular days. These are Exhibits 5 through 7. Mr. Chang will testify about Peanuts' business days, break days, and regular periods. Appellants have also provided analysis of proposed audited sales based on the actual business schedule, which is contained in Exhibit 8. The analysis shows that appellants are entitled to deductions of approximately $146,000. Appellants also dispute the average daily sales rate determined for the break period. The department came out for a site test one day during one of the weeks the department claims to be a break period, which happened to be the week right before the start of the spring semester on January 17, 2013. The average sales for this week was determined to be $1,230.95 per day. Mr. and Mrs. Chang's record of sales during true break periods show the average sales during the summer to be approximately 27% less, about $899 on average, and 48% less during the winter break, which amounted to about $645 per day. This is contained in Exhibit 9. Mr. Chang will testify that the week before the regular period starts, it's not truly a break period, and therefore the sales are unrepresentative of true break periods. The appellant's analysis shows that if the department used the sales data for true break periods, appellants are entitled to a reduction in audited sales of approximately $198,000 for the break periods alone. Additionally, Mr. and Mrs. Chang challenged the average daily sales rate determined by the department for these break periods. On January 17, 2013, there was a large number of students from a fraternity and their friends who came up to make up approximately 40 transactions, which is very unusual for a day during a break period. The department made an adjustment for 30 of these transactions, which did not sufficiently account for the unusual amount of sales on this day, which skews the data. Lastly, Mr. and Mrs. Chang dispute adjustments the department made for an additional 2 hours of sales each day beyond their posted hours.
During the regular schedule, Peanuts was open until 7 p.m. on Mondays through Thursdays. The department alleges they were open until 7:30, so the difference is only 30 minutes. However, the department applied 2 hours of sales calculated at 20 customers during the 2-hour period for the entire audit period. Mr. Chang will testify that during the break periods and in the summer, Peanuts regularly closed early and did not stay open beyond 5 p.m. Appellants have conducted analysis of sales during the regular schedule. The analysis shows that the appellants are entitled to reductions of anywhere between $20,000 and $29,000. Mr. Chang has prepared his testimony via a statement he would now like to read.
제가 예.
So,
예, 이렇게 이 케이스에 이게 바쁘신 중에서도 오셔가지고 대단히 감사하다.
well, thank you for the judges to handle this case.
Talk into the microphone. Thank you.
첫 번째는
First of all,
어디 하는 날에 어디 때 January 17, 2013.
so it was on January 17th, 2013, which was the audit day when?
Audit day is we are school business, so we have one of them Fred. actually, 그러니까 그때 보면은 우리는 저 멤버 우리 커스텀에는 저 멤버들이 많이 오거든요. 학생 멤버들.
Fraternity
member.
Fraternity?
Yeah.
There are lots of fraternity members who show up on that were customers of
Since there's a slight break, can I ask a quick question? Let me interrupt. If he's got a prepared statement, would it be okay with you if the interpreter read from that statement? They're both sworn, and we would be able to ask questions. It might make it easier, if you're willing.
Well, could we take a break so I could review the statement?
Oh, or we could continue as we're going, whichever. I just offered it as an idea.
I think we'd like to consider it, but we'd like some time to think about it.
2 minutes, 3 minutes? Yeah, okay, sure.
Judge, off record.
Yes, please.
Are all those microphones hot? Because I don't hear anything coming out of the speakers.
I stand with the mic because the interpreter will soft voice.
And she wants both her client's voice and yeah. But he was going like this, so it wasn't picking up, I'm pretty sure.
I forgot that point. It's not her translator.
You really take some concentration when you're dealing with simultaneous translation.
BOE used to put the simultaneous computer in the background and the text period.
So no one else had to hear. That would be. It wouldn't work for today because she wants it. Although it could still become part of the electronic record. God, it would be great if we had that ability in our hearing rooms. It'd be pretty easy to set up too. Just
첫 번째 어디 나온 날이
First of all, the date of the
Hold
audit.
on. So now we're officially back on the record. Do please talk into that microphone directly.
첫 번째 January 1월 17일 2013.
So January 17, 2013 was,
The first audit day.
that was the first audit day.
그날 어디를 했는데 그날 방학인데
So this was during vacation time
근데
when the audit occurred.
아주 서프라이즈 그러니까 내가 생각하지 않았던 그런 그룹 멤버가 한꺼번에 들어왔어요.
So there were a bunch of group members who had not expected came in that day.
예. 그렇게 많이 왔을 때
So when a lot of those people came in,
그때 어디타는 여자가 어디타는
this woman who
woman
was the
auditor.
woman auditor,
이거는 스페셜 데이이기 때문에
she said that that day was a special day.
이 커스텀은 이그젬션 하겠다 그렇게 얘기했어요.
She told me that those customers will be exempt.
그래서 내가 그 멤버들을 갖다가 이제 카운트 했어요.
I did count up the number of those members.
야.
Yeah.
근데 그 넘버를 카운트할 수 있는 이유는
The reason I was able to count the numbers
그 사람들이 다 드레스업을 했어요.
were that they were all dressed in a particular fashion.
예. 그리고 그 드레스업 그 멤버 더하기 걸프렌드나 그 프렌드가 같이 왔어요. 그게 기념식이니까.
So this was some commemorative occasion. So not only were those members there, but their girlfriends and acquaintances as well.
예. 영어로 한다면 ATO Initiates Day 그러니까 기념식이었죠. ATO 기념식.
So it was ATO, some commemorative day.
So we count around 40 people.
한국말. So we counted about 40 people.
예. 네. 그리고 그때 그리고 그날 끝난 날 그리고 이제 어디시 끝나고 나서 어디시
After the audit was over,
예. 하고 나서 그 사람이 G-탭을 갖다가 뽑았어요.
that person pulled out a Z tape,
그리고 우리가 며칠 있다가 그걸 픽업했어요.
and we picked that up a few days later.
야, 산호세 그 보드 이퀄라이즈 오피스에서.
At San Jose Board of Equalization Office.
근데 우리가 그 롤을 봤을 때
When we looked at the roll,
거기 하이라이트가 돼 있었어요.
some portion was highlighted,
야, 우리가 한 건 아닌데
which was not highlighted by us.
내 생각에는 그 어디탄 분들이 그 이그젬션을 하려고 했던 게 아닌가 생각합니다.
So I was wondering whether the auditors were trying to exempt that portion or not. 다시.
그리고 우리 방학에 대해서 하고 싶은데요.
So, and also I'd like to talk about the vacation time.
우리는 시즌을 비즈니스예요. 계절 학교 비즈니스.
Our business is tied to school activities, and it's a seasonal business.
그래서 8개월을 장사한다고 보고
So,
4개월은 베케이션이죠.
so you could look at 8 month as the regular business period, and 4 month as the vacation period.
그리고 그 안에 스프링 브레이크도 들어가고.
So, which would be inclusive of spring break.
그리고 땡스기빙 같은 거는 거의 홀 윅을 쉬다시피 한다고.
And during Thanksgiving period, almost the whole week goes by without any business.
그리고 보통 한 세메스터는 4개월인데요.
Normally, one semester is 4 months.
그래서 우리가 the end of 그러니까 1월 말에 시작해서
starts starting from the spring semester starting from end of January.
The end of January. 그러니까 3월, yeah.
The end of January.
January에서 May second week에 끝나요.
And ends in second week of May.
Yeah, like final까지 끝나는 거예요.
Up until the finals.
So we are the end of May, 그러니까 5월 말부터 8월 말까지가 학교 방학이에요, 여름 방학.
And summer vacation starts from end of May till the end of August.
그리고 가을 세메스터는
And fourth semester
그때는 8월 말부터
starts at the end of August.
So, second week 12월까지 하죠.
Till second week of December.
근데 그 어디 때는 1월 17일이었잖아요.
So audit day being January 17th.
17. 근데 스쿨 스타트가 학교가 언제 시작했냐면 January 23에 했어요.
And the school was to start on January 23rd.
그래서 보통 학교가 일주일 전부터는 전후로는 약간 비지하기 시작하다고.
And things start to pick up a week before the school starts and also 1 week after the school ends.
왜냐하면은 어떤 사람은 뭐 방도 찾아야 되고 책도 사고.
So some students need to look for housing. They have to buy books and supplies.
그래서 그렇게 많지는 않지만은 좀 비지한 편이다.
So things tend to get busier somewhat.
그렇지만 그 전후 그러니까 학교가 완전히 방학했을 때는 looks like a ghost town이에요.
But in the middle of the vacation time, it's almost like a ghost town. Yeah.
그리고 그리고 오픈 시간에 대해서 얘기를 하는데.
And if I were to talk about the hours that we are open.
hour. 그러니까 그때 January 17에 어디를 했을 때.
So on the date of the audit, January 17th.
할 때 probably January 16, the auditor called me.
I think it was January 16th that the auditor called me.
What time is your close? 몇 시에 닫냐고 물어봤어요, 저한테.
I was asked what time we close.
그때 우리 겨울 그러니까 vacation time에 close early 하거든요.
And we close up earlier during winter vacation time.
So we close 5 o'clock.
So we close 5 o'clock.
그렇게 얘기했어요.
That's what I told her.
그렇게 했지만은 그 사람이 그 vacation time까지 다 2 hour 갖다가
But she added 2 hours
extra
through the vacation time as well. Yes.
근데 summer 같은 때 보면은
But during summer
같은 데 보면은
period,
정말 그러니까 점심이 끝나면은
once the lunch hours are over,
정말 조용합니다.
It gets really quiet.
So 우리가 3시 반까지 기다리면서 크로싱 하면서 우리가 청소해 가면서 손님을 기다린다 이거죠.
So by 3 o'clock, 3:30, we start to get ready to close up while cleaning up, cleaning the store, the cafe.
그러니까 우리가 손님이 없는데 그렇게 오픈을 갖다 사람을 기다릴 필요는 없다는 얘기죠.
So what I'm saying is that there's no reason to stay open when there are not any customers.
So 내가 보일 수가 있어요. 뭐냐면은 우리가 저 준의 다른 리시트에 시간이 나와 있다고.
And can show you the receipts which show the hours for June.
Yeah, June
Yeah.
and July.
June and July,
Yeah, June and July at the 방학 때
during vacation
그걸
time.
보여줄 수 있다고 생각합니다.
I can show you that.
Yeah, I will be here. 그리고 우리가 can you do this one too? You don't need it. 오케이. 그리고 우리가 레귤러 된 우리가 보통 6시 30분이면은 크로스 할 준비를 하죠 항상 우리가.
So during the regular hours periods, we start to get ready to close up by 6:30.
Yeah, and clean up,
We do
clean up, and sometimes the last day 그러니까 저녁 클래스가 7시부터 시작해요.
Evening class starts at 7.
So sometimes 걔네들이 오더하고 빨리 먹고 가고.
So sometimes they order and hurry up to eat and then leave.
Yeah, that's why we are one side closed and we are closed like us.
뭐요?
그러니까 한 사이드는 닫으면서 우리가 클린하면서 크로스한다 이거죠.
So what I'm saying is, we start to close up on one side of the place and then still being open.
Yeah, like that. 그리고 그때 우리가 그때 모든 그 메뉴 프라이스가요 5불이었어요. 5불 around 평균이.
At that time, average price of an item on the menu was like $5.
그러니까 예를 들면은
For example,
그러니까 햄버거 with French fry
hamburger with French fries
$3.95.
was $3.95.
브렉퍼스트 같은 경우 2egg and hash brown 토스트가 2불 69전이에요.
Breakfast, 2 eggs, a hash brown, and toast was $2.69.
그리고 런치 스페셜이 with French fry가 3불 49전.
Lunch special with fries was $3.49.
근데 그러니까 우리가 언더 리포트 했다는 게 거의 이게 448,917불이에요.
So what the other side is alleging that
언더 리포트.
we had underreported was $448,917.
그러니까 거의 half a million에 가까운 거죠.
Almost $500,000.
그러니까 그렇게 언더 리포트 하기는 힘들다 이거죠. 이 프라이스로.
So what I'm saying is, with the prices we were charging, such low prices, it would be very difficult to be underreporting that amount.
그리고 제가 이 비즈니스를 35년간 할 수 있었던 이유가
The reason I've been able to run this type of business for 35 years,
가장 프라이스를 좋게 하고 로하게 하고
so was being able to maintain a very low, cheap price.
Yeah, that's right. 그래서 그 프라이스는 좀
That's it. Submit it.
Thank you. Do you have more, or does that conclude your presentation?
That concludes
Okay. Do you have anything else to add for your presentation in chief?
No, I'm happy to ask a question.
Panel? Questions?
I do have a question, probably for Mr. Chang or perhaps for counsel. I think he indicated in his testimony that during break time they closed at 5. Is that right?
Yes.
근데 그때보다도 더 일찍 닫을 때도 있었어요. 항상 사람이 너무 없으니까.
But sometimes we would close up sooner than that if there were no customers.
Samantha, for you, the Exhibit 4 indicates a 4 o'clock close time during petitioner's break hours.
That's correct. My understanding is that their posted hours, that they would close at 4 o'clock during the break period.
So Mr. Chang testified 5. Since the hours of operation is an issue, which was it?
Well, I think what he was saying, but he can clarify, was that they wouldn't be open beyond 5 o'clock.
열지는 않죠.
5시까지 열지 않는다는
Chang, would you sometimes close before 5?
장께서 다 듣고 5시 이전에 문 닫을 때도 있으십니까?
많죠.
Lots of times.
준하고 줄라이하고 미들 오브 어거스트까지는 그렇게 닫는 적이 굉장히 많습니다.
There are so many occasions during June, July, up until middle of August that we would close up earlier like that.
Break time sometime close before 4.
Break time 시에 4시 이전에 문 닫는 경우도 있습니다.
스프링 브레이크나 준, 줄라이, 어거스트에는 그렇게 닫지 못하죠.
There are lots of times we close up like that, either during the spring break, June, July, or August.
Thank you.
The panel doesn't have any additional questions. CDTFA, do you have questions for the witness?
We do not.
Okay. Then I think that concludes your presentation. We'll let the department go.
I just had some closing remarks. Then
Do you want that for your rebuttal, or do you want that now as well?
I guess I'll say this.
Rebuttal, okay. So CDTFA, go ahead.
May I,
Oh.
before you start, Mr. Lambert, perhaps we should pull the microphone away from, thank you.
In this particular case, the taxpayer operates a restaurant across the street from San Jose University. Upon audit, the taxpayer presented their records. The records were just of summary records. The detailed records were not available, such as the cash register tapes or the guest checks. Therefore, it was found that was an issue, that we didn't have the detailed records. And also, we took a look at the markup of record on the income tax returns for 2010 and 2011. The 2010 markup was 185%, and the markup on 2011 was 161%. For a restaurant that also sells alcohol, we considered that to be low for that type of business. In addition, the taxpayer was a cash-only business. Therefore, that in and of itself leads to audit issues. It was found that not all cash was deposited into the bank account. So based on this information, the department decided to use an alternative method. The alternative method in this case were observation tests. The first observation test was conducted, and the summary of that is on Exhibit B, page 24. And what I would point out from this particular test, or these particular figures, there's 4 days, is that we were only observing one of the days, which was January 17th. So we accepted the figures on the Z-tapes for the prior 3 days, January 14th, January 15th, and January 16th. Now, during that particular test, two groups were identified that frequented the restaurant that day. There was a fraternity and also a small group of special needs individuals and their assistants. The auditor allowed an adjustment for those groups based on 30 individuals at a rate of $6.75 an individual. It was difficult for the auditor to determine all people associated with those groups. If there's a comment on Exhibit D, page 1, and I'll read that. It's made at January 17th, 2013. It says, according to the second shift auditor, there are some students from ATO initiation, but not in a large group. Usually 2 or 3 together, and they are less than 15. So, we did make an adjustment for that, and I guess it could be argued that that wasn't unusual, and there should not be an adjustment for that. That if you basically take out the sales to both groups, what you're essentially saying is that there were never any sales to large groups during the audit period. So therefore, even if you accept the appellant's argument, we believe, first of all, we don't accept that it was over that amount, but if you do believe that, we believe that a certain amount of those sales should remain in the test in any case. The calculation of the underreported taxable sales is on Exhibit E, page 5 and 6.
What's the bait stamp for that, if you know?
The bait stamp, oh, okay. Yeah, it's 50, I believe 55 and 56.
Exhibit E?
Exhibit E, page 5 and page 6. So this is essentially how the liability was calculated. And this was done after the appeals conference. So I believe the reference to $448,000 in underreported sales, that figure is from the initial audit. If you look at one page earlier, which is Exhibit E, page 4, column D, it'll show you what the current amount is, which is $391,420. So if you do notice column B.1, there was an adjustment made for hours to basically accommodate what we believe the hours are currently. There were different hours used in the initial audit. And so this adjustment here is to adjust for some of the errors that the appeals conference holder found in the numbers that in the hours that we used. So the hours that were used in the re-audit are Monday through Thursday, 6:30 a.m. to 7:30 p.m., Friday, 6:30 a.m. to 6:30 p.m., Saturday, 7:30 a.m. to 4 p.m., and always closed on Sunday. So that's how the figures were, how this audit calculated the figures. Now, the appellant has provided some proposed schedules, and their hours of operations appear to be different, or their argument is the hours are different than what we've used in our audit. So if you look at Exhibit G, page 6, which I believe is the back of a menu, it shows the same hours that we used. Exhibit G, page 12, is the hours that are on Google, which are the same hours that we used. The hours on Exhibit G, page 14, from Yelp, are the same hours that we used. The hours Exhibit G, page 25, which is online menus, is the same hours that we used. I will also point to the observation test that was conducted on January 17th of 2013. That test went until 5:30 at night, which is different between the varying hours that have been argued throughout this audit, anywhere from 4 p.m. being closed to 5:30 p.m. being closed. And so initially, we were told they close at 5:30. When one of the auditors went by the business, they noticed that they were operating later than that. And that's when this issue came to light. Regarding the number of break days, if you look at Exhibit 5, page 9, and look at May 25th of 2010. It showed the taxpayer is recording that as a break day. If you look at our Exhibit B, page 12, and go to May 25th of 10, what you'll show is sales of $1,474. It does not appear that that is a break day. We've not recorded it as a break day. This is considered one of our spring semester days, and we recorded it as such. If you look at Exhibit 6, page 9, and refer to May 24th of 2011, it also shows a break day. If you reference our schedule, Exhibit B, page 13, the sales, taxable sales for May 24th of 2011 are $1,433. Again, this doesn't appear to be a break day. If you refer to Petitioner's Exhibit 7, page 9, there's 2 days, May 15th of 2012 and May 23rd of 2012. Both of these are recorded as break days in the taxpayers' schedules. If you look at the department's Exhibit B, page 14, it shows May 15th as $1,315 in taxable sales, and May 22nd, 2012 as $1,459.
First, when you were describing the,
You know what, I did, I may have, I should have referred to May 22nd of 2012.
all right,
On Exhibit 7, page 9.
okay.
If I did, that was my error.
So we cut you off. The sales for
So the
5/22.
sales for May 22nd of 2012 were $1,459, which does not appear to be a break day. So I believe the appellant has argued that they believe the day before the day before the semester starts, they consider that not to be a break day. Their schedules are inconsistent with that statement. Their schedules show that the sales before school starts are all break days in all 3 years. So, unfortunately, we only have their records for a short period of time. In other words, on each one of those schedules that I referred to of the departments, it only has 1 day of the week for about 4 months or so during the spring semester. So we do not have a full record to address each one of what they consider to be break days and what we consider to be break days. The bottom line, we believe that the taxpayers' schedules don't appear to be consistent with what their actual records are and what probably took place, which is what the department has shows in their records. In regards to the large groups, the appellant's Exhibit 3 has a listing of all the sales that were made to the fraternity. And if you add up all of these, I believe the argument's been made that there's 48 transactions, and I will say there are 48 transactions on the appellant's Exhibit 3. What I would point out is that some of the sales appear to be maybe multiple customers. I mean, we don't have, I'm unable to read the cash register tape, so it's difficult to say. But if you look at customer number 145, $15, 146 is $32, 152 is $13, customer 157, $20. 170 is $16. Customer 181 is $18. And customer 185 is $41. What I'm pointing out here is that if you take the 48 customers, I shouldn't say that. I should say, if you take the 48 transactions and you figure out actually how many customers are on here, you're probably getting closer to 60 than even what was alleged of the 40. So this schedule appears to have more sales on here than, or more fraternity members than has even been argued. As far as the mark on the cash register tape, I've spoken to the auditor, and she denies that there were, that she placed the mark on the register tapes of the yellow highlight. And she believes the appellant is the one that put that on the cash register tapes. The letter from the fraternity stated there was approximately 40 fraternity members. I'll point out that that letter was dated 4 days after the test, but it was not presented until the appeals conference, which calls into some question in regards to the timing of that letter. Also on the cash register tape, that was not brought up until after the appeals conference. So if, and this is my last issue, if you take a look at Exhibit G, page 5, and this is, I think this goes to the reasonableness of the department's audit. If you take a look at column C, it's the taxable sales that have been reported by this taxpayer. And there, if you see, there's a line after the third quarter of 2012. That was at the point that the taxpayer was notified of an audit. As you can see, those amounts are substantially less than the amounts after that quarter. The sales increased substantially after the taxpayer was notified of audit. And the amounts that are being reported after the third quarter of 2012 are consistent with the audited amounts found in column E. What I would point out, this schedule was prepared before the appeals, or it was prepared before the re-audit adjustments were made. So the amounts in column E are slightly higher, well, basically combined a little over $60,000 higher than what they ended up being. So even with that, it makes it where the taxpayer is reporting more than what the audit came up with after they were notified of audit. So accordingly, the department rests their position.
Okay. Questions from my panelists?
I have one from Mr. Lambert.
Hi.
You said an auditor went by the facility and noticed it was open later. Is that reflected in the audit work papers, that observation and a notation of what he or she saw?
It is. It is in the it's in the audit history assignment audit history, which is called the 414Z. Unfortunately, my recall doesn't tell me what exactly date, and there is a number of entries in there, but it is included in there.
And I have none. You wanted to have a rebuttal, so we'll allow for that now.
With respect to the January 17th site test date, the argument is not that it's unusual to have large groups visit the restaurant at once. The argument is that it's unusual for such a large group to visit the restaurant during a break period. So the break periods, again, are the periods between the end of one semester and the beginning of the other semester. The week in which this observation test occurred was right before the spring semester. As Mr. Chang has testified, students are coming in to get situated with their housing, buy their books, socialize, fraternize, and so there's social events that week. There is a big difference between the week before school starts and, let's say, the 2 weeks for the Christmas break, the holiday break, or any month in the middle of summer. The department used this week's sales to determine the audited sales for all the break periods. That is unrepresentative of actual sales during the dead of summer or during the dead of winter. The hours of operation are important, and we're not arguing that there's a differing that the appellants have had differing hours and they close at times when business is slow, or they may stay later at times than the posted hours. It's important because they rarely stay open during this for an extra 2 hours beyond the posted hours for the summer months or for the 2-week holiday months. And it's unfair that the department has adjusted 2 additional hours of sales for the entire summer break period when sales were really slow. Mr. Lambert has commented that after notification of the audit, the appellants began reporting sales that were more in line with what the report suggests. The appellants have provided information regarding the sales for the summer of 2013, which was after the audit period, and for the December month of 2013, which is after the audit period. The data from those periods show that they were actually closed on average by 4:30 during those periods. The department did not include the 2-hour sales period for Fridays, Saturdays, Sundays, and the months of October, November, and December, which it's just not how the restaurant operated. They would stay open during the regular school semester as they had to because there were more students. When there were less students, they didn't stay open that late. I think that's all I have. I would point that the appellants have summarized their proposed adjustments on Exhibit 11. The individual exhibits 4, 8, 9 provide information about how the appellants determined their proposed adjustments. We're not suggesting that the appellants were perfect in their bookkeeping records, in their accounting records for the audit period, but we are asking the panel to consider the real circumstances of a small restaurant operating across the street from a university, which is the primary customer base. The information and the proposals that are presented by the appellates reflect the actual fluctuation of the business because of the academic calendar. And I think that's all we have.
Okay. Any questions? No questions? No. All right. I think that will close the record, and we will conclude the hearing. I want to thank each party for coming in today. And following this hearing, my co-panelists and I will discuss the case and the evidence and the arguments, and then we will issue a written opinion within 100 days. And so with that, this hearing is now closed. Thank you.
Thank you.
And we take a 5-minute recess to trade out panels.
Yeah, I will.
I'm Mr. Berman.
Scotta's not in attendance. Yeah, he care for their child. Yeah. Yes, correct, Scotta. I had the same question.
Okay. You are,
Adam Berman.
okay, and you are?
Nick Wagner.
Okay. And Tasha? Okay. Is that Natasha?
Yes.
Yeah, that last one's probably brutal, honestly.
That's from the income tax down like sexy.
Yeah.
Now, since you're the demand guy, you're ready, so I'm gonna just let you take it if they get weird. Yeah, I'm ready. Board things and you're like,
Good morning. Before we go on the record, is everyone here? Court reporter, are you ready? Okay, let's go on the record. We're now on the record in the Office of Tax Appeals oral hearing for the appeal of Adam M. Berman and Alejandro Scotta, case number 18043054. We were in Sacramento, California. The date is Wednesday, September 25th, 2019, and the time is approximately 11:15 a.m. My name is Josh Lambert, and I'm the lead administrative law judge for this hearing. And my fellow co-panelists today are Jeff Njija and Jeff Margolis. Morning. Appellants, could you please identify yourselves?
My name is Adam Berman.
I am Nick Wagner, representing Adam Berman and Alejandro Scotta.
FTB, could you please introduce yourselves?
Yes, my name is Joel Smith.
And I'm Natasha Page, also representing FTV.
The appeal involves one issue, which is whether the notice and demand penalty should be abated. During our pre-hearing conferences, we already agreed to admit into evidence appellants exhibits 1 through 6 and FTV's exhibits A through G, and neither party had any objection. Is that still correct?
Yes.
Thank you. So I hereby admit those exhibits into evidence. As we agreed, appellants will have 10 minutes to present their argument, then we will ask questions and FTB will ask questions,
and FTB will make its presentation not to exceed 20 minutes, and appellants and the judges will ask questions, and after that, appellant, you can give a rebuttal for 10 minutes. Okay, and as I understand it, Mr. Berman, you'll be testifying as a witness? Okay. Can you please stand and raise your right hand? And repeat after me. Do you solemnly swear, or just say yes after. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Okay, appellants, you have your opportunity now to explain your position.
Good morning, Your Honors. Nick Wagner, representing appellants Adam Berman and Alejandro Scotta. The issue before you today is whether the penalty for failure to respond to a notice and demand letter was properly imposed by the FTB upon the appellants, as well as whether the appellants have shown reasonable cause. The appellants respectfully ask that this body abate the penalty imposed upon them for their perceived failure to respond to a letter sent to them to their address on the 13th of June, 2017. They do so based on the grounds that the penalty has been improperly imposed upon them by the respondent, and the facts of their case easily establish reasonable cause for failure to respond. The appellants are being penalized under California Tax and Revenue Code 19133, which imposes a 25% penalty against the taxpayer's liability for failure to respond to a notice and demand letter within the requested period, usually 30 days. The driving theory behind this penalty is simply to get a response. While the appellants will speak to the details of their experience, the legally relevant facts of this case are simple. The appellants were on a 4-month sabbatical abroad to recover from events which Mr. Berman will explain. That trip spanned from April to September of 2017. During that time, they charged their neighbor to scan for their mail. Due to an oversight on behalf of their neighbor, Mr. Jake Stuckey, the FTB's notice and demand was missed and not forwarded to the appellants while they were abroad. The appellants arrived back in the U.S. on the 21st of September, and after viewing the notice, called the FTB the next day on the 22nd. In that call, the appellants explained their situation to the FTB and advised them that they would file their return in early October. And in fact, by October 8th, well within 30 days of actually receiving the notice, the appellants filed their returns. The appellants contend that these facts demonstrate sufficient due diligence to merit a finding a reasonable cause for their failure to respond. The appellants here took every reasonable step a person could take to ensure that their mail was sent to them. Were it not for the human error on the part of Mr. Stuckey, the appellants would have
Mr. Wagner, could you please talk a little slower so the co-reporter can follow along? Thanks.
Were it not for the human error on the part of Mr. Stuckey, the appellants would have received the notice. These facts stand in bright contrast to the facts of the appeal of Winston R. Schweihart, referenced in our reply brief. In that case, the appellant moved from his home permanently and asked a friend to collect his mail and forward it to him. Like the appellants in the present case, the friend made a human error by losing the address and decided simply to put all the appellant's mail in a drawer. The court there found that the appellant was not acting as a prudent taxpayer and decided that such facts did not constitute reasonable cause. However, in the present case, the appellants were not moving permanently, but rather traveling abroad for a set length of time. And the system that they set up with Mr. Stuckey ensured that even if there was a piece of mail not forwarded to them on their trip, they would still receive it upon their return. It appears to the appellants that the FTB seeks to penalize them for failing to respond to a notice that they never saw. This strikes the appellants as unfair, as it is completely unreasonable to expect someone to take action in response to something that they have absolutely zero knowledge of. Despite this, the respondent chose to impose the penalty for their failure to respond under Code 19133. In this case, the demand letter was sent from the FTB only sought specifically a tax return for 2015. The purpose of the statute 19133 is only to motivate the taxpayer to respond. It is not a late filing penalty. That is Tax and Revenue Code 19131, and the respondent might have chosen to penalize the appellant under that statute. It occurs to us that the respondent is attempting to solidify precedent through this case so that the FTB may impose whichever penalty it prefers, late filing or notice and demand, when dealing with taxpayers who find themselves in situations such as the appellant. Your Honors, the appellants here are hardworking taxpayers who have never found themselves in a situation like this in 30 years. Despite failing to file for their return, the appellants paid and overpaid all their taxes on time throughout this ordeal. The respondent here is applying the laws of our tax system in a systematically rigid way in order to achieve the penalty they seek. This statute does not function as a protective measure for the state's revenue, but rather as a cudgel by which the respondent punishes taxpayers into compliance solely at the respondent's whim. To penalize them to this extent for not seeing a piece of paper, despite taking steps to avoid this from occurring, is not in keeping with the spirit of our tax code. For these reasons, we respectfully ask that the court look favorably upon the appellants and find that the penalty against them should be abated. Your Honors, thank you for your time, and I look forward to any questions you might have.
Thanks. Is that a concluding your presentation, or Mr. Berman, you can speak.
Thank you, and good morning, everyone. I just wanted to provide a little more context, very briefly, and really elaborate a bit on what had happened to us. So look, prior to 2013, we filed all of our tax returns on time, and that happened over more than 30 years. In 2013, we were subject to really quite an extraordinary set of circumstances surrounding the birth of our son, Emilio, and that caused us to be unable to file our returns on time for the subsequent 3 years. Alex, or Alejandro, I call him Alex, my husband, is not able to be here today and expresses his regret that he can't be here, but he is taking care of our son, and our son had to be taken to school this morning. But we always when we met back in 2008, we always wanted to figure out a way to have children. And after careful consideration and significant due diligence, we decided to work with the Surrogacy Center of India, a Delhi-based agency, and also the largest surrogacy center in India. We did a lot of due diligence on them. Our surrogate eventually became pregnant in February of 2013, and our son was born in October of 2013. My mother and I traveled to India for what was supposed to be 17 days in October. That's about the time that's required to get what's called the consular, essentially the equivalent of a U.S. passport. It's a very straightforward, simple process. About 10 days after he was born, and we were already taking care of him at this point, we learned that I am not his biological father, even though that was what was supposed to have occurred. The U.S. Embassy rejected our passport application for Emilio, and they told me at that time that it might take 10 years to get Emilio into the United States. They actually said they couldn't even make that promise. They told me at the time that the only other couple where this occurred left India, and their child went into an orphanage. We were determined not to let that happen. It didn't matter. Once we had our son, it didn't matter that he was not biologically related to us. He was part of our family. He was our only son. He was my mom's only grandson in the family. We were determined to bring him home no matter what, even though the odds and there was no precedent, there was no path, and we were committed to doing whatever it took. We engaged the world for support, from lawyers in the United States, India, and Argentina, geneticists in the United States and Israel, Senator Dianne Feinstein, Leader Nancy Pelosi, Homeland Security, the U.S. Citizenship and Immigration Services, and a host of folks who I'd never met in India who also came forward to help. Eventually, we were able to bring our son home, and in 2016, Emilio became a U.S. citizen. The only bad actor in our story is the agency and their partners, who committed a series of egregious crimes in connection with the birth of our son. The full range of crimes is described in detail in the criminal complaint that we filed with the police in India back in June of 2014, a copy of which you have been provided. I also wanted to point out that Senator Dianne Feinstein's letter in January of 2014 to U.S. Citizenship and Immigration Services requesting their assistance is a really nice 1.5-page summary of what occurred. So that's just a bit of context. The only other thing I wanted to mention was, and actually Mr. Wagner touched on this, we went on this sabbatical from April until September to recover from the trauma of what had happened in India and to rebuild our relationship. As Nick mentioned, our neighbor Jake was offered to help and scan and forward essential mail. As background, we probably get 10 to 20 pieces of mail every day. He did not forward this notice from the FTB while we were on vacation. So we didn't receive the notice until September of 2017. If we had received the notice when I was on the trip, I would have called the FTB and I would have simply said, we are not able to file the return for various reasons, and we would have explained it to them on the phone in a what would have been a 2-minute phone call. We didn't have that opportunity. We all anyway, it is just unfortunate. I'm kindly asking you to rule in our favor. I've been an on-time taxpayer my entire life, and Alex and I have been on-time taxpayers again since 2016. In every case, I've always paid what was owed, even when we were not filing the returns on time for that 3-year period. And in fact, in probably most of the last 15 years, including the year in question, I overpaid what was owed. So I would request that you abate the penalty. I'm happy to respond to any questions.
Thank you, Mr. Berman. FTB, do you have any questions?
I do not.
Judge and GJ, do you have any questions? Judge Margolis?
I'm not sure how relevant it is. I just don't understand why you said that your 2013, 14, and 15 returns were unable to be filed on time. You didn't really explain why that was the case. I'm curious why that was the case.
So we were in consultation with our accountants and also a tax lawyer to really figure out how to treat the theft loss that is related to what happened to us in India.
So the purpose of the trip was a sabbatical, okay. And then you've discovered, so you're saying you eventually discovered the amount of the theft loss, and is that one reason why it took longer to file your return?
Now, so the theft loss was just very complicated to figure out how to treat the theft loss. And so our accountant and our lawyer, our tax lawyer that we had to retain to figure all of this out, it just took a lot of time to really figure out what to do and how to treat it. And so we eventually, so we were also waiting for the criminal proceeding in India to play out because we were waiting to see if there was going to be any recovery. By late 2017, not late, but by basically September 2017, we realized that there wasn't going to be, and we were able to catch up, but we actually filed the 2013 and 14 returns in early 2017. And then the 15 return was filed in October of 17, and then all of the rest of the returns have been filed on time since.
Just to confirm, you paid your tax timely for 2015?
Yes, in full. In fact, in our original letter to the Office of Tax Appeals, dated March 20, 2018, I'm just going to quote from this. All 2015 taxes were paid by April 15th, 2016, and no taxes were owed on the return that was filed. In fact, I overpaid my taxes by $53,277, applied $39,000 to 2016 estimated tax, applied $2,072 for a late tax penalty, and was due a refund in the amount of $12,205.
Thank you. FTV, you can present your argument now.
All right, thank you. Good morning. Based on the September 11th, 2019 request from your office, it appears that there might be two issues in this appeal. The first issue is whether a respondent properly imposed the demand penalty for the 2015 tax year. And as I will explain, under California Code of Regulations, Title 18, Section 19133, imposition of the penalty is proper. The second issue is whether appellants have established reasonable cause to abate the demand penalty. The record shows that appellants have not established reasonable cause to abate the penalty. The facts are not in dispute. When respondent did not receive a timely 2015 tax return from Mr. Berman, respondent issued a demand for tax return in June of 2017. When respondent failed to receive a response, respondent issued a notice of proposed assessment in August of 2017, imposing the demand penalty in accordance with Regulation Section 19133. Thereafter, appellants filed their 2015 tax return. Respondent accepted the return and adjusted the demand penalty accordingly. The demand penalty is calculated based on the amount of tax shown on the return. It does not take into account timely payments. With regard to the first issue, respondent imposed the demand penalty under authority granted by Revenue and Taxation Code Section 19133. This section gives respondent discretionary authority to impose the demand penalty. As a result of this discretion, respondent promulgated Regulation Section 19133 in 2004. Under Regulation Section 19133, Subdivision D, the demand penalty for appellant's 2015 tax year is proper because respondent issued a prior NPA to Mr. Berman for the 2014 tax year. The rules of statutory construction govern the interpretation of regulations. California courts have held that the fundamental objective when interpreting a regulation is to determine the intent of the agency issuing the regulation. To start, courts look to the plain meaning of the language to determine the agency's intent. Under Butts v. Board of Trustees, which cites to Code of Civil Procedure Section 1858, when interpreting a regulation, courts must first give meaning to every word and phrase in the regulation. Courts must read the regulation as a whole, and courts cannot omit what has been inserted into the regulation. After considering the entire regulation, if the plain meaning is ambiguous or inconsistent, California courts give great deference to the interpretation of the regulation by the promulgating agency. California courts defer to the agency's interpretation when the subject regulation addresses an area of the agency's expertise, touches on policy issues within the agency's purview, and when the agency has shown consistent enforcement of the regulation. Like California courts, the United States Supreme Court has repeatedly given deference to the promulgating agency unless the interpretation is plainly erroneous or inconsistent with the regulation or the interpretation does not reflect the agency's fair and considered judgment on the matter. With regard to Regulation Section 19133, the plain language in subdivisions B and D creates ambiguity in the regulation. Therefore, deference should be given to respondents' long-standing interpretation of the regulation. As earlier stated, Revenue and Taxation Code Section 19133 grants respondent discretionary authority to impose the demand penalty. In order to provide uniform exercise of that discretion, respondent promulgated Regulation Section 19133 nearly 15 years ago to provide clear direction to California taxpayers. The intent of the regulation was to codify respondents' demand penalty policy to penalize recent, repeat non-filers. Regulation Section 19133 was promulgated after substantial analysis on the imposition of the demand penalty and with input from the three-member Franchise Tax Board. Respondents' interpretation of the regulation provides certainty to taxpayers. Respondent will impose the demand penalty if it issued a notice of proposed assessment to the taxpayer for one of the 4 preceding tax years. An alternative interpretation that ignores respondent's intent and ignores subdivision D of the regulation creates confusion and puts taxpayers at a disadvantage if their distant filing history can expose them to the demand penalty. Respondent's interpretation of Regulation Section 19133 reflects the agency's fair and considered judgment. It is not erroneous, and it is not inconsistent with the regulation. Therefore, deference should be given to respondent's interpretation. Therefore, respondent properly imposed the demand penalty under Regulation Section 19133 Subdivision D. Now, as for the abatement of the demand penalty, under Revenue and Taxation Code Section 19133, respondent's imposition of the demand penalty is presumed proper unless appellants are able to show that their failure to timely reply was due to reasonable cause and not due to willful neglect. Appellants must show that the failure to respond to the demand occurred despite the exercise of ordinary business care and prudence. In addition, appellants have a personal, non-delegable obligation to timely respond to the demand. Now, in this particular matter, the time period at issue is from when the demand was sent to when the demand required a response, and that's from June 13th, 2017 to July 19th, 2017. Appellants suggest that they were not responsible to timely respond to the demand while they were in Europe because their neighbor did not forward them the demand. This does not establish reasonable cause. As mentioned, appellants had a non-delegable obligation to timely respond to the demand. The same rule even applies to taxpayers who rely on a tax professional, such as a CPA or an attorney, to respond to a demand. Appellants were responsible to timely respond to the demand and could not transfer that responsibility to anyone. As such, based on case law and evidence in the record, respondent requests you sustain its position. I can answer any questions that you might have.
Thanks. Appellants, do you have any questions for FTB? Judge Njija? Judge Margolis, do you have any questions?
Yes, I have a few questions. Mr. Smith, in your opening statement, you said that the FTB has discretionary authority to impose this penalty. What I don't understand is why didn't you exercise that discretion here when the taxpayer credibly says that they didn't get the letter, and when they did get it, they promptly took this into account. And in exercising this discretion, I guess, I've read your package about the intent behind this regulation, and I think one of the problems that was noted there is that this penalty is so harsh and that it doesn't take into account any prepayments. And here, the taxpayer had overpaid. Why isn't that a factor that you take into account in deciding to exercise your discretion when the taxpayer is overpaid and clearly did not receive the actual notice that they reply within 30 days?
Okay, so I'm going to try and answer all of those. If I miss one, please alert me to one I missed. As for the discretion is in the Revenue and Taxation Code section itself that the legislature wrote. It says that the Franchise Tax Board may add a penalty of 25%. So, given that discretion, respondent promulgated the regulation 19133 to make sure that that discretion is uniformly applied to all California taxpayers. And in addition,
were you saying that by issuing that regulation, that's the only manner in which you can exercise your discretion?
Well, so I'm speaking to the discretion in the statute. Right. And so that is what has been, the regulation creates a uniform application of the discretion. Now, as it relates to abatement of the penalty, the regulation, or excuse me, the statute says that the taxpayer needs to show reasonable cause. And so that's the second piece to this. And the reasonable cause analysis is whether someone acted as a prudent business person in this matter, during that month that the demand was sent to the taxpayer's address, taxpayers admitted that it was sent there, taxpayers admitted that it was received. The time period that matters is that month where the demand requires a response. And in this instance, being out of the country is not reasonable cause. So the discretion isn't related to the reasonable cause. It's not whether you impose a penalty here or impose it there. So the regulation ensures that the penalty is equitably applied to all taxpayers.
But I guess from reading the package, it said that one of the problems that you were the taxpayers and the tax community had with the statute is it was such a harsh penalty that applied when taxpayers had full paid and had overpaid. I mean, this taxpayer was potentially subject to a late filing penalty. I know that he was full paid, so the penalty would be just a flat fee if that was the case. But they have a penalty for filing late. This penalty is for not responding to a notice, so it seems to me that they should actually get the notice before you can impose the penalty, especially since it's so harsh. I don't know if the last known address rule that you seem to be applying here, that all you have to do is mail out the notice and you're going to presume that the taxpayers received it and then impose this admittedly harsh penalty here.
I'm not entirely sure what packet you're referring to. In this particular matter, the regulation has not been briefed, so I can't speak to the packet that you're referring to. As for, I'm not entirely sure what packet you're referring to.
This is the package it's a pretty standard package that you filed in several 19133 cases where the issue of the prior year's notice has come into effect. I mean, you did refer to the legislative history. I assume that you've reviewed those materials. The legislative history relating to the regulation. So I assume you're familiar with that.
Right now, I just wanted it to be on the record that this has not been briefed in this appeal.
Is the FTB doing some sort of clarification of its regulation in this matter? Is it working on that?
Recently, FTB was given permission to proceed with the informal regulatory process. Any adjustments or amendments that might be made have no bearing on this appeal.
I don't think I have any other questions. Oh, I do have one more. I mean, if the taxpayer had made a phone call, if he did get this thing and when the notice was issued in June, and he had called the FTB, it is the FTB's policy to grant a reasonable extension, isn't it?
Correct. As shown on Exhibit A, page 1, the demand outlines options available to the taxpayer. And real quick, sorry, you had mentioned the last known address rule. The legal standard for respondents' notices is that notices are sent to the taxpayer's last known address. There's been no allegation that this was sent to the wrong address. There's been no evidence to suggest that respondent was on notice to provide documentation to any other address. So the Franchise Tax Board did meet its legal standard by issuing this demand to the taxpayer's address.
Do you have any authority that last known address rule applies when the penalty is imposed based upon a failure to respond to that notice? And as I understand, the law requires that a notice of additional tax be sent to a last known address. So whether you get the notice or not doesn't matter. But here you're sending them a notice saying respond by a certain day, and it just seems to me that there should be there's actual receipt of that. I mean, I'm not saying a taxpayer would be off the hook if they, purposefully ignore their mail. I just don't think that was the situation here.
There's no legal authority that stands for the last known address being applied differently in a situation where a response is required. The last known address is applied uniformly for all notices sent by respondent.
Thank you very much.
Okay, appellants, you can make your rebuttal now.
Thank you very much. The respondent holds that it met its burden by simply sending the letter to the last known address. It holds this as an irrebuttable presumption. However, we believe the facts of this case clearly show an example where the last known address rule cannot be considered an irrebuttable presumption. There are larger ramifications for applying this rule so narrowly. The appellants here actually took genuine steps to ensure that their mail was received. They were acting as a prudent business person. They can't control the errors made by someone that they charged to take care of their mail. I contend that not every taxpayer makes such diligent steps as the appellants in this present case when they take extended trips. More often than not, taxpayers in the state take long vacations without making any arrangements for their mail. The FTB would have this panel believe that the last known address is irrebuttable. I offer that the only irrebuttable fact here is that the appellants did not receive this mail. Next, I'd also question whether or not this is really consistent enforcement. As Judge Margolis, you mentioned, they could have gone with a late filing penalty, but they didn't do so in 2013 or 2014. How would the appellant honestly be expected to understand the gravity of these notices if they aren't consistently enforcing them? Thank you very much.
Thanks. Any more questions? All right. Okay, well, I'm going to close the record and conclude the hearing. So thanks to both parties for coming. And following this hearing, we will discuss the evidence and argument and issue a written opinion within 100 days. Thanks. This hearing is now closed.
Thank you.
Thank you.
We're going to take a 5-minute break.
I'm going to give you that tomorrow. Whatever that 200. Well, I don't have it. I gave you the phone. But you haven't. How am I supposed to get you more?
we're currently off the record, but are all the parties ready to proceed?
Yes, sir.
And while we're still off the record, Mr. Kiriakos, did you decide whether you will be testifying in the narrative or reading from a prepared statement? Sir, I'm going to have you hand that to Mrs. Seiler, and she will distribute a copy to the respondent, and she will also share copies with each of the panelists. And while she's distributing copies of your prepared statement, question, are you still planning to play an audio recording at some point during your presentation?
I have it available, Your Honor, if there is a need to play.
And we'll leave that up to you. If you do decide to play, it will be during the 20-minute portion of your opening presentation. Will we go on the record? Are there any questions from either party? Okay. Hearing none, we are going to go on the record. So we are on the record in the matter of the appeal of Zaki and Kiriakos, OTA case number 18-05-3178. This hearing is taking place in Sacramento, California, September 25th, 2019, and the time is approximately 11:55 a.m. The panel of administrative law judges consists of Michael Geary, Josh Lambert, and me, Alberto Rosas, and although I may be the lead administrative law judge for purposes of conducting this hearing, I would like to point out that the three of us, we are all equal participants, equal decision makers. We're going to get started with stating your names for the record. We'll start with the taxpayer.
Yes, Your Honor, Zaki, Kiriakos.
Thank you.
Shannon Paval, representing the Franchise Tax Board.
Natasha Page, Franchise Tax Board.
Thank you, everyone. And I would like to point out this hearing is being recorded. We have a stenographer, so I would like to just remind everyone to please speak slowly, speak clearly, and please try not to speak over one another. I just want to go over a few administrative matters. We held a telephonic pre-hearing conference earlier this month on September the 4th. We discussed various matters, and that resulted in the issuance of 5 orders. I'm just going to discuss those on the record. Mr. Kiriakos, your exhibits 1 through 4, 7 through 10, and 12 through 14 were admitted into evidence without objection. Number 2, FTB, you objected to exhibits 5, 6, and 11. The objections were overruled, and exhibits 5, 6, and 11 were admitted into evidence over FTB's objection. And Mr. Paval, in a moment, I will give you an opportunity to voice your objections for the benefit of the panel.
Thank you.
Item number 3, FTB's exhibits A through G, that's Alpha through Golf, were admitted into evidence without objection. Number 4, we agreed that one witness, Mr. Kiriakos, would testify at today's oral hearing. And number 5, we agree that the parties will comply with specific time limits and that today's oral hearing should take no more than 1 hour. Is this an accurate summary of the pre-hearing conference orders?
Yes, Your Honor.
Yes, Judge Rosas.
In terms of the objections discussed, Mr. Paval, you previously objected to exhibits 5, 6, and 11. Please, by all means, explain your objections.
Thank you. In respondent's pre-hearing conference statement, it only reserved a right to object to exhibits 5, 6, and 11, absent an offer of proof from the appellant. At the pre-hearing conference, the appellant made an offer of proof as to why he believed those documents were relevant. And at that conference, the appellant stated that he believed exhibits 5 and 6 concerning decisions from the Veterans Administration saying that he was disabled as of a certain date were relevant to prove disability. And he made the same offer of proof in regards to Exhibit 11, which was a finding that he was disabled as of a certain date for the Social Security Administration. The respondent still does not see how those documents, Exhibits 5, 6, and 11, are relevant to show that the payments made by Lockheed Martin constituted paid family leave. So with that being said and that clarification issued, the respondent still objects to the introduction of Exhibits 5, 6, and 11 because they are not relevant to the issue.
I believe that by excluding these exhibits that I'm offering as my only proof that there is a large period of 2011 where I was unemployed due to disability, that takes away my ability to prove, and the burden of proof is on myself to show the reason why I'm claiming what I'm claiming. During my conference hearing with the FTB officer back in 2017, when I was stating my case to her at the time, she basically said, anything that you can provide that would prove what you're telling me, by all means, please, do so. So this is why I'm providing this evidence. It's not, the intent is not to go through them in detail. They are official records that show, that there is a substantial evidence that supports my claim.
Thank you. As mentioned, these exhibits have been admitted, but I want to thank you once again. The panel will take this into consideration when we decide what weight to give Exhibits 5, 6, and 11.
Thank you.
We will now move into the next phase, oral testimony and presentation. Mr. Kiriakos, as we discussed, you will have up to 20 minutes. Before you begin, I'm going to ask our stenographer to administer an oath.
I do.
Thank you.
Kiriakos, it is my understanding that you are reading from a prepared statement. Whenever you're ready, sir, you may begin, and please take your time.
Honorable members of the panel, this is my written declaration. I just wanted to give you a background as how we're here. It all began with an honest response to a seemingly straightforward interview question in the 2011 version of TurboTax. The question was, is any portion of your income due to family leave or separation pay? I responded by checking the yes box. And just to fast forward through a timeline very briefly for you, and what is important to get from that is that I was prompt in every response, and my actions were very timely and consistent, and wanted to resolve matters as soon as they became aware of them between myself and FTB. So on February 24, 2012, I did file a timely 2011 tax return. I filed it electronically, and it was accepted on that day, and I have provided proof of that as Exhibit 7. On September 25th, 2015, which was more than 3.5 years later, I was issued a notice of proposed assessment from FTB, and that is found in Exhibit 8, which I received on October 9th, 2015. That NPA stated that a claimed income deduction of approximately of $106,152 was disallowed from my filed return, and as a result, FTB had proposed an additional tax liability amount of $10,096.31. Excuse me. And on October 13, 2015, I contacted FTB to get further clarification as to what caused that additional assessment. And the FTB examiner that I spoke with at the time informed me that it seemed as though my entire schedule of deductions for that return was rejected, and the return was currently under audit conditions. So he wasn't able to provide me any more detail, but he did advise me to respond to the notice within the timeline that it was, that was stated. So I did respond. I had no other information except what was given to me by that initial examiner, and I filed my response on November 14, 2015. On November 22nd, 2016, which was a year later, more than 1 year later, FTB sent me a reply to my protest, and which I didn't receive till early December. And in that reply, basically it stated that it had disallowed subtractions of wages that didn't conform to California law. So on December 6th of 2016, I submitted a request for an oral hearing, and on November 15, 2017, a year later, I had my oral hearing. So I attended that telephone hearing with a very understanding about my FTB hearing officer. Ms. Alina Nalbandian, before I actually had that meeting with her, I sent her a lot of documents. I just sent everything I had. It was difficult for me to dig them out because we had just got back to the house from being evacuated after the fires we had down in Santa Rosa in October. But I sent everything that I could possibly find that related to the case. So in that conference, Ms. Nalbanyan, she honed in on a certain payroll item which is submitted here as Exhibit 2 and 13. And if I might direct your attention, Exhibit 13 is a lot clearer. It's the same thing, but it's just clearer version. She noted there's some entries on my pay stub. Now, Lockheed Martin is a government contractor. So by law, they are required to annotate anything that relate directly to earned pay that as it pertained to the government contract. I was a government contracting officer, so I also very familiar with how earned pay should be reported. Anything that's fringe benefit or anything that's related to a fringe benefit needs to be addressed separately. So the pay stub was detailed in that. It broke it out in that order, and she was actually looking at that. But what she did tell me that the earned pay amount is clear for regular pay to be $57,744.01. And she said that absent of a 1099-G filed with the state of California, she could not admit anything else that would relate to sick leave, family leave, or paid leave that isn't reflected on the required form. Now that in itself was a problem because Lockheed Martin and I were not on the best of terms, and she encouraged me to reach out to them and try to get that particular form. She said without that form, she didn't have the authority to overrule or to adjust the NPA. So then I immediately contacted Lockheed Martin, and the exhibit that I submitted as Exhibit 14 basically captures their response, which was flat out, we're not going to do it. And with a citing of basically federal regulations as to why it wouldn't apply in this case, which wasn't true. I clearly worked on a government contract. It was a government-funded contract. Therefore, anything that didn't relate to a regular pay that was part of a fringe benefit, and in this case is substantiated, would have to be reported, but they didn't do it. So in March of 2018, I received the final notice of action, and that was for an amount of $9,208 plus interest accrued to a total of $11,004.78. Now, what I wanted to kind of explain to you, because Ms. Nalbanyan encouraged me to also pursue or elevate to a higher authority, if you will, than herself, and request a special special dispensation based on my circumstances. So in order to convey what are those circumstances, I want to kind of take you through a quick timeline of 2011, how my personal situation was. On April 28th of 2011, so roughly 1/3 of the year in, I was placed on a paid suspension from Lockheed Martin until July 4th of that year. Meanwhile, an official correspondence from Lockheed Martin, again, a copy of which was all provided to Ms. Nalbanyan, that I went to all of my department. I had 160 plus people in my department, telling them that their senior manager was on family leave, taking care of personal business. On June 16th of that same year, so roughly 6 weeks later, my former wife, Carol, she filed for divorce. And the arrangement was, I had a job with Lockheed Martin Space System Company in Sunnyvale. My home was in Encino, in the San Fernando Valley, in Los Angeles. So I would commute to work weekdays, and I would be back in Los Angeles on weekends. Well, she demanded that I would actually stay at my apartment in Sunnyvale. Within a couple of weeks after that, Lockheed Martin has changed my status to unpaid suspension and recommended my termination from the corporation. So I had no choice but to try to appeal that decision to Lockheed Martin Corporation. But because they gave me an official termination at that time, I was able to file for unemployment compensation with the state and the federal. And so on September 7, Lockheed Martin Corporation upheld the company's decision and basically cemented my termination status and coded my personnel file as ineligible for rehire, and which basically sealed my fate. And then the final check pay stub is what you see here as Exhibits 2 and 13. So that in itself was the personal side. On the financial side, I was dealing with a lot of financial issues. Had $400, roughly $400 a week in unemployment as my only source of income at the time. Some retirement money from not a lot, and VA benefits were not in place yet. So I had rent, I had legal fees, divorce related, as well as unemployment related, and then I basically had no other choice but to sell investment stocks that we had at loss, great losses, just so I can continue to survive. So that in itself created some erroneous entries that I ended up making, and I can expand on those later. So in reality, I was unemployed as of April of that year. I submitted Exhibits 5, 6, and 11 to clearly substantiate my claim. It supports the fact that I was unemployed as of July 4th, 2011, as clearly stated in Exhibit 11. And not only was I unemployed, it's also stated as I was unemployable. So the earnings that are reflected for that year were basically a combination of unemployment benefits, regular pay, and some inaccessible shared community property revenue that was generated from my selling of investment stocks. Those stocks were seized, or the revenue was seized. I had no access to it. Nonetheless, it was reported as part of my income, and that in itself made my liability much higher. Excuse me, and how am I doing on time? I'm sorry.
You've been speaking for about 13 minutes.
So what am I asking specifically from the panel, from the honorable panel, is an exception. I'm requesting that line 7 on Exhibit F, column B, which is page 4 of Exhibit F, and that's Respondent's Exhibit F. Line 7 and column B specifically. I'm requesting that that amount, instead of the $106,000 as reported, it to be adjusted to only $48,408, taking into effect that my regular pay, which is consistent with the Exhibit 13, is $57,744, which in reality, when you look at my my pay rate at the top of that same exhibit is $178,644. That is for the entire year. That's my annual pay rate. So a third of that, roughly, is that amount, which correlates to what I'm saying, is that after April, I was not earning a pay in a regular sense. So by taking that out and making that exception to be, or the deduction be $48,408, and also because of the community property division of assets that ended up happening after I liquidated our investment stocks, only half of that amount should be reported as additional pay or additional income. It's reported as a capital gains, and that is on line 13 of that same page, and that's column C. So the $81,919, if that was split in half as it was done, my individual capital gains income would be $40,959. So by taking those adjustments in, then that takes my my deduction to $119,000, which would be on page 1 of Exhibit F, and that would be line 17, would be $119,665, as opposed to what was reported initially.
Because you have 4 more minutes, and I'm not sure if you want to play that audio tape, which takes about a minute and a half, but you have 4 more minutes.
Thank you, Your Honor.
Certainly.
So so line 14 that was reported as a, I'm sorry, line, I lost my space, my place here for a second. Line 13, which was reported, I apologize again. It's line 17 on page 1 of Exhibit F. Instead of the $102,881, it becomes $119,665. So roughly $120,000 instead of $102,000. Now, respondent has not disputed my itemized deductions, and if I would keep the same itemized deductions of $78,964, taking that from that new total, my taxable income would be $40,701 for that year, which in reality takes my net liability to just around $992, and that would be the calculation based on that. Just making those two exceptions for my circumstance. Thank you for your time.
Kiriakos, did you want to play that audio tape at this time, or are you going to proceed without it? It's up to you, sir.
It's a minute and a half.
Certainly. And just to be clear, this is the audio file associated with Exhibit 14, correct?
Yes, sir.
Hello, this is Police Cook, the Zaki Barton County Service Center, and this phone call is for Mr. Zaki Kiriakos. So we spoke back on November 16th, and you are inquiring with regards to a 1099-G, and your question was that this income should be reflected with regards to personal illness paid in the amount of $31,606.22. You stated that in the state of California it's supposed to be reflected on a 1099-G as separate income because it's taxed differently. And in our discussion, I told you that we would research this for you. You were having some issues with the IRS with regards to the payment. So the research did find that the Form 1099-G is not used for vacation or PTO payments. It's filed by federal, state, or local governments only. So per the IRS government Form 1099-G, certain government payments do apply, but it's not that type of payment, not PTO. The only payments apply is unemployment compensation, state or local income tax refunds, credits or offsets, or reemployment trade adjustment, taxable grants, or agricultural payments. So to answer your question, this will not be reflected. Your PTO time is not reflected on a 1099-G, so this is not something we can actually supply to you. If you have any further questions, give us a call back. That number is 1-866-562-2363. Thank you, and you make it a great day.
That was the audio, Your Honor.
Hey, Mr. Kiriakos, FTB, do you have any questions for this witness?
No.
Turn it over to my co-panelist, Mr. Geary. Do you have any questions for this witness?
Mr. Kiriakos, regarding the reduction of the capital gains, is that you're requesting a reduction because half of that money went to your ex-wife? Is that the reason?
That is exactly the reason, Your Honor. In fact, I did not have access to that money until March of 2013, which is when the divorce was made final. Thank you.
Lambert?
No questions.
And as for me, Mr. Kiriakos, I just wanted some clarification. What was the amount that you're saying Lockheed Martin paid you in 2011 that is related to family paid leave?
They're broken in a few line items, Your Honor. One of them is clearly articulated on there as family leave, paid leave, $31,000. There was also another amount that was personal business and the vacation payout. All of these were used up in conjunction with my case, my status at the time, my condition. I basically used up everything I had available to me. I think the legal mandate, whether it's applied to the Davis-Bacon wages or other mandates, is that they only have a certain allotment of fringe benefits per employee, and once one is exhausted, they would use the other one as well. And like if there's one that is colored as personal time versus sick time versus family time or paid leave. They're all different, but they're all actually, in essence, used for the same intent. But they're recorded differently or reported differently.
Next question. Walk me through, because during your presentation, you were indicating that the reduction should be, give me 1 second here. I think you were referencing Exhibit F during your presentation, page 4, and you said that the subtraction should be $48,408. So walk me through, how did you arrive at that number? And I see on the pay stub that $36,000 you were talking about, but walk me through and explain the difference, how you totaled.
I only considered the regular pay on the pay stub, Your Honor, which is $57,744.01 as the reported, that should be reported as regular pay, which is what was reported. Anything superlative of that, I consider that to be due to my condition at the time, and that should be considered a subtraction. And when you total those amounts, that's basically what I put in there, Your Honor.
Thank you, Mr. Kiriakos, for that explanation. At this point, I'm going to turn it over to the Franchise Tax Board for the presentation. You have up to 10 minutes, and you may begin whenever you're ready.
Thank you, Judge Rosas. Good morning, Judge Geary. Good morning, Judge Lambert. I'm going to refer to all three of you as the panel for purposes of my argument. I hope that doesn't, you don't take any offense to that. This panel should affirm FTB's notice of proposed assessment of additional tax and interest of $10,000, 96 and 31 cents, because FTB properly disallowed the appellant's Schedule CA Line 7 deduction of $106,152. The appellant has the burden to prove that that amount was entitled to be deducted. As we're aware, the respondent conforms to Section 61 of the Internal Revenue Code for the definition of gross income, except when it doesn't. For items like paid family leave, those items are taxable at the federal level pursuant to IRC Section 85. RMTC Section 17073 says that Section 85 does not apply. Therefore, the respondent properly disallowed the deduction of $106,152 from the tax return. Now, the appellant is alleging that a portion of that amount was attributable to paid family leave. But the evidence doesn't show that. The evidence actually shows that no amount was for paid family leave. If you go ahead and turn to Exhibit E of respondents' exhibits, it's a letter from the California Employment Development Department. And when FTB is dealing with paid family leave, it sends a letter to the California Employment and Development Department to see if that agency issued a 1099-G for paid family leave. And Exhibit E illustrates that no amount was issued on a 1099-G to the appellant for paid family leave. So there was no paid family leave issued by the California Employment and Development Department. This process works, and it's evidenced in the receipt of a 1099-G for the unemployment insurance compensation that that the appellant referenced in his opening. If you give me 1 second, that is what is Exhibit D. If you look at Exhibit D, page 3 of 5, you will see a 1099-G issued by the California Employment Development Department to the appellant in the amount of $10,350 for unemployment insurance. That's what we should see if any amount of the $106,152 that was deducted on Schedule CA line 7 was for paid family leave. That's how that program works. The appellant is pointing us to Exhibit 2, a copy of his last pay stub. And let's go ahead and turn and look at let's look at Exhibit 13 because it is more clear. When you look at Exhibit 13, on the top under Hours, Earnings, and Reimbursements, you will see on the very last line item, it says Absence, Non-FMLA, Family Medical Leave Act, Paid. You follow that across, you'll see Hours, $368, $31,806.22. The key there is non-FMLA. And that's consistent with the receipt of unemployment insurance during that paid suspension time. The appellant's own testimony says, I was on a paid absence, suspended. So that means during that period of time, he was not on FMLA, he was on a paid suspension absence from his position with Lockheed Martin. The regulation, CFR 1.85-1, specifically says if it's not for paid family leave or another government type of compensation like unemployment insurance, disability insurance, and those types of insurances, then you revert back to Section 61. And that's what the respondent has done here. And that's what this panel should affirm, because that is the law. And there hasn't been evidence submitted to this panel today to show that any amount is entitled to a characterization of paid family leave. And that would be the same for the vacation payout. If you're paid vacation, that's included in gross income as well. So no amount should be allowed in regards to the $106,152, and this panel should affirm the respondent's position in this case. I will just reference that the sole issue in front of this panel today is whether or not the respondent's actions in disallowing the $106,152 on Schedule CA line 7 was appropriate. It was, and there's been no credible, competent evidence to the contrary on that point. And with that, the FDB submits. Thank you very much.
Thank you, Mr. Preval. Mr. Kiriakos, if you wish, you now have an opportunity to rebut FTB's presentation by making a closing statement and providing additional testimony, and you will have up to 10 minutes.
Thank you, Your Honor. I'm arguing with the California law as far as the proper reporting based on having it in 1099-G, Your Honor. And that was why we're here, is because it was explained to me, absent of that 1099-G, it would take a higher authority to make an exception. But my effort to provide the panel with proof that I was in a status that was somewhat difficult at the time, physically, psychologically, emotionally. I cannot get into a lot of detail, Your Honor, obviously with the time that we have. I did provide exhibits that would show that there are two federal agencies that found that to be true and determined I was unemployable as of a certain date, both of which found me disabled as of that date in 2011. I cannot provide a 1099-G because I have a former employer who didn't want to provide one. I was on for a good portion of that, on a family paid leave. I don't know why it's not categorized as such and the proper paperwork filed. That I have no answer for. But just to go back to respondent's comment about vacation payout, I can refer you back to the 48,408 figure that you had asked me about, Judge Rosas. I did not include in that number the entire $27,311, which was a vacation payout. Only a fraction of that was included in that amount. There is a portion that's almost 32,000, and there are some other figures that I did not include. So I'm not asking for a consideration of the entire amount. What I'm asking for is basically something that pertain to my family paid leave that I truly was under. But I have no other proof, Your Honor.
Thank you, Mr. Kiriakos. At this point, I'm going to turn it over to my co-panelists to see if they have any questions of either party. Mr. Geary?
I have no further questions.
Mr. Lambert?
No questions.
Just have a few clarifying questions. Mr. Kiriakos, I understand your position in terms of the subtractions that you made. Some of it, based on your testimony here today, is that it was vacation pay. Part of your other testimony is that some of it was paid family leave. Help me see this from your point of view so I can wrap my brain around this. What is your position in terms of why you believe Lockheed Martin paid family leave in 2011?
I was physically and mentally unable to perform the job, Your Honor. And I was placed on a family paid leave status and was communicated accordingly. And that was also communicated to the government whose projects we were on. Other than that, Your Honor, going through the interview with, excuse me.
Take your time, Mr. Kiriakos.
Sorry, but I just asked the previous ones last week, so. The interview question was simplistic, but looking back, that TurboTax question I'm referring to, it created a lot of problems. And I clicked yes, but there was no opportunity to even put in a figure. It just, one of those things where it goes from one screen to the next and out it shoots the California income tax return, which is very different from the federal income tax return. You know, my particular exhibit, which had the federal portion, shows that the itemized deductions were well over 120,000 or something like that, 124,000, and which is well above the $78,000 figure that the state of California laws allowed for that return. So I did not think twice about, at the time, I didn't even think twice about, is there a problem with it? It wasn't until 2015, 3.5 years later, when I got notice that there was a problem with that figure, because it went from that screen to completing the return, when in reality, I thought in my head it did not matter what portion of my family, what portion of my income was family paid leave, because my $120-something thousand deductions made it all seem moot or, obsolete. So it wasn't until later, 3.5 years later, we're actually pouring through those numbers that I figured, well, there's the problem. And I hope that answered your question, Your Honor. But
Yes, thank you, Mr. Kiriakos. FTB, is there anything else you would like to add?
Nothing further. Thank you.
Kiriakos, you are the taxpayer, the appellant. You do have the burden of proof, so I do want to give you the last word. Other than what you've already testified here today, other than what you've already submitted in your pleadings and in your exhibits, is there anything else that you think this panel needs to know in order to make a well-informed decision? Thank you, Mr. Kiriakos. In that case, that concludes today's hearing in the appeal of Zaki and Kiriakos, OTA case number 1805-3178. The record is now closed, and the matter is submitted as of today, September 25th, 2019. This panel will issue a written decision to the parties no later than 100 days from today. Thank you all very much.
Thank you.
Thank you.
does. I just do it. I mean, I used to roll it to the freight elevator.
And then that's your corner in there, right?
Yeah, that's my. Hey Marcel, we're done. Just wanted to let you know. No problem. Thank you. All right. Bye.